those words. Well, go ahead and recite them, please.
Yes, thank you, Judge. I would like to begin by reading out a statement. This ex parte hearing is in the matter of CFI 054-2019 before Justice Sir Richard Field and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Clyde & Co. Lead counsel is Michael Black. The defendants are not present.
Right, so thank you very much. Mr. Black.
Thank you, my lord. My lord, this is a without notice application for a post-judgment freezing and provision of information order, principally against Mr. Al-Jabri, the third defendant, and against the fourth and fifth defendants, Ali Mohammed and Elite Holding Group Limited, whose very existence is still unclear, even at this stage in the proceedings. As my lordship was aware, on the 14th of September, we filed an application to extend the pre-judgment orders, and you directed that it should be a separate application.
Yes.
And this is the application. And in the interests of full and frank disclosure, when the defendants see this, we wished to make it clear that we did make that application.
Yes.
And that you directed that we made this application instead. My lord is of course familiar with the facts of the case, making judgment on the 15th of August and a revised judgment with editorial corrections on the 30th of August. A number of matters have occurred since the close of the evidence, some of which my lord may be familiar with and some of which will be not. And indeed, some of those issues will have to be dealt with inter partes, particularly in the context of an attempted application for permission to appeal out of time on the sole ground that my lord lacked jurisdiction. And that application is currently being made by lawyers, as we see, who initially declined to go on the record, but that is for another day. My lord, the facts are set out in detail at paragraphs 16 to 43 of Mr. Hutchison's fourth affidavit.
Yes.
And may I just highlight the principal ones?
Yes, could you just wait just for a moment while I've printed it off. I just need to have it.
Yes, of course.
Yes, do go on. I have it now.
Thank you, my lord. So, the third defendant failed to comply with the court's order made on the 27th of May of 2021 to provide the information which is set out at paragraph 10 of the affidavit. That records the order that was made, and if one turns back to page 4, my lord again may recollect that order, details of source of funds, an updated list of his assets worldwide, explanation, etc. That sets out verbatim my lord's order of the 27th of May. That has not been complied with. On 17th June, his then lawyers, Bird and Bird, came off the record, and Mr. Al-Jabri communicated directly with Clyde & Co. On the 3rd of August, my lord made the passport order. It was served the next day on the 4th of August in English on Mr. Al-Jabri and in Arabic on the 10th of August. On the 11th of August, Mr. Al-Jabri had a telephone conversation with Ms. Dalamy of Clyde & Co., in which he expressly refused to comply with my lord's order. On the 25th of August, LAMAG exercised the option given in the judgment to have the bonds returned in specie rather than accept damages representing their value.
Yes.
The next day, Mr. Al-Jabri again wrote to the registry saying he had appointed new lawyers, BSA Ahmed bin Hazim and Associates. But they then claimed on the 29th of August that they were only instructed to appeal and would not engage in relation to any matters concerning the judgment. And in particular, they would not accept service of any documents We have submissions on that, but as I said, that is, my lord, for another day.
Yes.
For their part, the first and second defendants, the bank essentially, FAB, have stated through their lawyers on 8th September they will not transfer the bonds to LAMAG unless Mr. Al-Jabri instructs them to do so, or there is a court order. Again, the court order is perhaps something for another day, but if my lord has access to the exhibit to Mr. Hutchison's affidavit, which is marked A4, if I can just take you to page 157, it's a letter from Al-Tamimi and Company on behalf of...
Yes,
FA.
I read it yesterday or the day before, but do go on, just refresh my memory.
Yes, I just wish to read two short paragraphs. The above order does not require FAB Securities, being the second defendant, to effect transfer of the Reditum bonds absent any instructions by the third defendant. Therefore, until the third defendant does give any instructions or the court orders it to do so, without the third defendant's instructions, FAB Securities will not transfer the Reditum bonds to your client's account in Luxembourg.
Yeah.
So the situation as we have it now, post-judgment, is that Mr. Al-Jabri has failed or refused to comply with orders of the court to disclose his sources of funding or assets. He has expressly refused to comply with the passport order, which he described in the conversation with Ms. Delamy as a joke, and he has failed to comply with the judgment by giving instructions to FAB to hand over the bonds, nor has he paid or made any attempt to pay the monetary damages. And indeed, he's attempted to remain a litigant in person for the purpose of the service of documents. As to Mr. Al-Jabri's continuing business activities, which is...
Well, could I interrupt you for a moment? Do forgive me.
My lord, yes.
I made an order as part of the judgment where I summarized the relief that was being granted, well, set out the relief that was being granted, that within a particular period of time, an affidavit be sworn by Mr. Al-Jabri in aid of the restitutionary claims.
Indeed, my lord, yes.
And as I understand it, that has not been complied with either.
No, my lord. As a matter of convenience, again, Mr. Hutchison sets out verbatim my lord's judgment, which you'll find on page 5 of his affidavit. And indeed, the order that my lord is thinking of is paragraph 15.1 of the affidavit of Mr. Hutchison. That has not been complied with. That is correct. Well, in fact, none of the orders that my lord made in his judgment, or indeed any interlocutory order, has been complied with. My lord, so turning to Mr. Al-Jabri's business interests, and the reason I do that is because of the proviso to a freezing injunction about the normal course of business, which we say on the authorities is not appropriate in this case, but we also say is not appropriate on the facts for the reason that I will show you now, if I may. If my lord would be kind enough to go to the bundle A4 annexed to Mr. Hutchison's affidavit, you'll see we have exhibited a page of a transcript of Mr. Al-Jabri's evidence under cross-examination.
Yes.
And at page 159, we have the 4 pages to the page version, and it is the bottom left-hand one that I should like to take you to, page 15 of the transcript.
Yes.
I was asking Mr. Al-Jabri about his business, which he said was a Rixi Capital. I asked him when it started trading, and he said it's not ready to do any business in Dubai. And then I asked whether it has any business in the USA, and he says not anymore, no. So that apparently, again, my lord may recollect, was his evidence as to his business interests, which appear therefore no longer to be trading. That takes us to the legal position, and the first point that I have to make, and we make in our written submissions by way of full and frank disclosure, is we accept that there is a legal argument that the pre-judgment orders lapsed on the 30th of August. Yes. We say there are arguments against that, not least that the judgment required further actions to be undertaken before, if you like, the relief is perfected. But that again is an argument for another day, if it is necessary to argue that. But on a full and frank basis, we need to disclose that.
Yes.
So we do. So what we are seeking effectively is a continuation of the pre-judgment order with some changes to take account of the fact that we are post-judgment. I'm sure my lord is very familiar with the principles involved, but if I may take...
well, by all means, I have had my recollection refreshed by reading the skeleton argument for the application that was issued on the 14th. And the authorities are very carefully set out in the skeleton argument. And I'm quite satisfied that the court has jurisdiction to issue a freezing order after judgment to continue until the judgment has been satisfied. And we have the judgment of the Deputy Chief Justice, Sir John Chadwick, as far as a local authority is concerned, and we have compelling English and Wales decided authority as well. And so I don't need for further persuasion, A, that the court has jurisdiction to issue a freezing order after judgment, and B, that in the circumstances of this case, it is appropriate, right, and proper that the order you seek, subject to some small debate between the court and yourself as to the precise wording, is an order that will be issued.
I'm grateful for that indication, my lord. There are then two remaining points. The first is whether or not the order should contain the ordinary course of business proviso.
Yes, it currently does, doesn't it? The orders I've received this morning, the draft orders, I think I'm right in saying, contain the ordinary course of business exception.
I don't think the draft does, my lord.
Ah, well.
Unless I've missed it too, and if anybody wants to correct me on.
Well,
yes, it is not there now, my lord. I thought.
Ah, well, just forgive me for a moment while I look through the orders that I read this morning, which had come through overnight, so to speak.
It would have been under Section 4 exceptions.
Well, it is in what I've printed off from the link that Mather sent me. Section 4 is headed exceptions to this order.
Yes.
There is a spending of permitted of $5,000 a week.
That's on living expenses.
That's living expenses.
In the interim order, the next clause was legal expenses, and that has been omitted.
Sorry, I've rolled the two up together, and I shouldn't have done. So this is living expenses only, but so far as meeting, it's yes. Yes. Well, good that we clarified that. Thank you.
So I need to persuade my lord to omit that. There are a couple of authorities on that I should be grateful if my lord would be kind enough to look at.
Yes.
One is the Masri case.
Yes.
So we're back in 2008.
Yes.
And at paragraph 35 of the judgment of Mr. Justice Tomlinson, as he then was, he said this: the ordinary course of business proviso as directed at the hearing on the 18th of July will continue in the receivables freezing order. It is obviously necessary in order to allow the contracts to continue to be performed in the usual manner. The freezing order in respect of the bank accounts have contained no provisos since it was granted on 19th May, and there is no evidence that the absence has caused any actual disruption. For the avoidance of doubt, I do not read paragraph 27 of Mr. Marina's 6 statements providing such evidence, etc. In any event, I'm satisfied that in relation to assets such as balances in bank accounts, an ordinary course of business exception is inappropriate in the post-judgment environment. I respectfully adopt the reasoning of Mr. Justice Coleman in the Soinco case, which I set out above. That was, of course, a case concerned with a receivership rather than a freezing order, but it seems to me that those considerations apply a fortiori to a post-judgment freezing injunction. Things then moved on even further. 11 years later, we have the Court of Appeal in 2019 in one of the Wilson cases. If you have the mic.
Go on.
At paragraph 56, the Court of Appeal, in the English Court of Appeal, said this: fourthly, it can be said, however, on the basis of nomihold at paragraph 33, that, quote, it will sometimes, and perhaps usually, be inappropriate to include the exception in a post-judgment moreover injunction. Given the policy of the law strongly in favour of the enforcement of judgments, as already remarked, it would indeed be curious with a position otherwise, leaving the judgment debtor free to carry on business and ignore the outstanding judgment. The context is that a risk of dissipation must already have been demonstrated, as otherwise no moreover injunction, with or without exception, would have been granted at all. Accordingly, over the period between judgment and execution taking effect, a moravia without the exception serves to hold the ring, and quotes a judgment of Sir Jeremy Cook. So the English Court of Appeal indeed is endorsing the idea that it's usually inappropriate to have the ordinary course of business proviso. And of course, in this case, Mr. Al-Jabri has confirmed, as I showed my lord a moment ago, that he has no business in any event. So we are pretty much in the same position as they were in Masri in relation just to bank accounts rather than trading in receivables. And so we would submit on the facts of this case, it would be inappropriate to have the ordinary course of business exception. Yeah. The other legal point is this. I mentioned before an attempt at appeal. We strongly, of course, oppose that, and that's a matter for another day. But let us assume for the moment that it enjoys a prospect of success. And let us also assume that Mr. Al-Jabri were able to persuade the court to grant a stay on the basis of that proposed appeal. We would still say that that would not be a reason for not granting the injunction. And that was considered by Mr. Justice Hamlin in SPL private finance. And if I could just, my lord, to paragraphs 12 to 14 of that case. Yes. Where he says this: I turn to consider the primary submission made by Mr. Farrell, which is there is no purpose or justification in continuing the worldwide freezing order in the light of the fact that a stay of execution has been granted by Lord Justice Voss pending the determination of his application for permission to appeal. This has been directed to be heard orally. Paragraph 13, Mr. Farrell submits that in the light of that stay, there is no need for a freezing order to assist in relation to execution, because as matters stand, there can be no execution. In my judgment, that is a false point. The purpose of the freezing order is to preserve such assets as may be available pending the execution process. That process has been held up by reason of the stay, but the underlying need to preserve the assets remains. The effect of the stay simply is to prolong the period of time over which the protection may be required. Further, it is right to observe that one of the matters relied upon by Lord Justice Voss in reaching the decision that there should be a stay was the existence of the worldwide freezing order. For all those reasons, I do not accept that the grant of the stay of execution provides an overarching reason, or indeed any reason, why the freezing order should be set aside.
Yes.
In what we respectfully submit is the unlikely eventuality that he be given permission to appeal, and the even more unlikely eventuality that he grants a stay, that would in any event not be a reason for not granting the post-judgment order. And so with those two lines of authority, may I turn to the order itself, my lord?
Just before you do, if I may.
Yes, of course.
I was sent two draft orders, but they look as if they're identical. And so you confirm, do you, that you're seeking one order, you're not seeking two distinct orders?
I'm not seeking two orders, I'm seeking one order. We will, of course, notify the order, indeed, not only to the three named defendants, but we will inform the bank as well.
Yes.
Even though the order is not made against them.
Yes.
We certainly undertake to inform them of it. That's one of the undertakings in Section B in any event.
Yes.
But we can travel reasonably quickly through the order, because it is a recitation very largely of what my lord has already ordered.
Yes.
In Section 1, that is a recitation of the order of the 24th of November of 2019. Section 2, paragraph 2.1a requires an explanation of the number 64,352,669.
Yes.
That is the total of the monetary compensation awarded by my lord. It does not include interest or costs, but it does include the value of the bonds that my lord assessed at 57,715,500 euros. We have elected to take the bonds in specie, but we do seek a freezing order in their value until such time as we actually do receive the bonds back. As you have seen, they are at the moment still with the bank.
Yeah.
And so we don't have either the bonds or their value, which is why we've sought a freezing order in the full amount.
Yes.
The other parts of the Section 2 are a recitation of my lord's order of the 3rd of August 2021, which listed out the various properties which Mr. Al-Jabri claimed to possess. Section 3, and indeed 3.1, is from the original order in November 2019, and he is still in breach of that. And then we come to the section we looked at a moment ago, exceptions to the order.
But I'm so sorry to interrupt you again, just looking at Section 3.
Yes, my lord.
After the original freezing orders were served, which required the disclosure of assets.
Yes.
There was some disclosure of assets made by the third defendant.
Yes, he didn't. Yes, which is why there was the further order asking that he give proper disclosure of them. And so, my lord, 3.1, if you like, is the overarching order. 2.3 relates to the specific assets that that he chose to disclose in your lordship was persuaded was an incomplete way, which is why he was asked to provide further information. So we do still seek 3.1 as the overarching.
Well, is there a danger of unnecessary duplication? He has already provided information which you contend is incomplete as to his assets. 3.1 is asking him to undertake the entire obligation of disclosure again. Is there any room for an exception to the extent that disclosure has been made?
Yes, I mean, my lord, I can say, as my lord was making the point, I can see immediately that we could perhaps put an exception in for those assets listed at 2.3 A, B, C, and D, so that he's not obliged by this order.
Yeah, having already done it. Yes,
having already done that.
Well, I think that would be preferable.
Well, my lord, we can certainly do that.
Well, that was the only point I was going to make on Section 3.
I'm grateful, my lord. On Section 4, we've already
yes.
noted that we've omitted the course of business
yes.
Proviso, and then finally in Schedule B are the undertakings, and we have maintained the same undertakings, including indeed the sum of 350,000 euros as ordered by my lord as security for the cross undertaking and damages. We felt it would be inappropriate at this stage to start playing around with our undertakings and just keep it simple.
Yes.
So, my lord, basically that is our application.
Yes. Well, now, just give me a moment.
Yes.
Uh, 9.6 assets located outside the DIFC. Now, I think this is the Babanef rider. And I take it that it is effectively word for word for what conventionally has been required, where there are assets outside the DIFC following the Babanaft decision.
I will just make sure that is right. I'm sure my learned junior will confirm that. If your lordship will forgive me for a second.
Yeah, no, certainly.
And I'm also told there should be Schedule B, there's a typo. Yes, in Schedule B, Little Roman, there are two Little Roman 2s. It should be, so it should be Little Roman 3.
Yes, actually, it's in Schedule B3.
Yes, that's right.
Well, you just have to make those changes.
I'm just waiting for confirmation on the Babanaf provider.
Yes.
I'm pretty much sure it is. Yes, yes, it is the standard.
Right.
Yeah.
Good. Well, now I have already indicated that on the material put before me by way of the affidavit, the fourth affidavit of Mr. Hutchison, the skeleton argument, the exhibits to that affidavit, which include the judgment that I was issued on the 15th of August. I am well satisfied that the court has jurisdiction to make the order that is sought, and that in the circumstances it is appropriate, which I think is the language of the DIFC provision relating to the grant of injunctions, but which, as Sir John Chadwick said, was really no different from the wording of the equivalent English provision, that it is right and proper and just that this order should be made. I will produce a short judgment which will set out shortly in more detail than I have just identified the reasons why I am making the order. When I shall be able to issue that, I'm not sure, but I hope to be able to get that done in the next few days. And so the next step is that a clean copy of the order that we've agreed should be issued should be provided to the registry, and which should be sent to me, and I will then immediately respond to the registry on the assumption that the order is in proper form, and the registry should issue it as soon as possible after I have given my approval.
Yes, my lord, I'm reminded, something I should have dealt with. The order calls for a return date.
Yeah, oh yes, it does call for a return date.
We're in my lord's hands. Obviously, a party can apply on notice in any event to.
Well, if there's going to be a return date, which I suppose there should be, it's not going to be in the near future. I have a DIFC trial starting on Monday, and who knows what the amount of court time will be necessary on a return date. It may be something that can be dealt with very quickly, but it may not be. Now, I think I should just have a quick look at my diary, Mr. Black. Give me a moment while I get my diary. Well, I think the return date I would propose would be Monday, the 25th of October.
My lord, my attention's being brought to RDC 2512.5. May I just look at that, because it does say something about return dates there.
Yeah.
It says, when acting under the procedure set out in this part, the court shall set a return date for the hearing of the application before a judge sitting alone, which shall not be later than 3 days from the date upon which the interim order is issued.
Well, the court has power to extend.
Yes. And a party does have the right to apply, obviously, to discharge.
Well, it's a slightly curious position because...
Yes, this is said to be an interim order in any event. This is well, the heading of the section is interim remedies, and it may be argued that a post-judgment freezing order is not an interim remedy in any event.
Even if there were a return date in 3 days, it may be that almost inevitably in this case, a date would be given for an adjourned hearing.
Yes.
For the court to be able to accommodate it.
Well, my lord, the other parties do have liberty to apply.
Yeah.
Whether under the rules, it being an ex parte order anyway. If they don't like the date,
yes.
No doubt they will not be backward in coming forward on that.
Well, I think we should put a return date of the 25th of October.
My lord, obviously we're in my lord's hands. It would certainly be appropriate, because there are other matters to be dealt with, not least whether there is actually going to be an appeal or not, and if that is going to be determined before
well, that
the
will
20th.
almost certainly be determined on the papers, I think.
Yes.
I mean, one can't be certain about that until one's seen the application and the grounds which are advanced.
Yes.
In most cases, applications for permission to appeal are dealt with on the papers, particularly at first instance, where the application has to be made first to the trial judge.
Yes. So it may be, my lord, that by then there will be some clarity about the appeal, which will assist my lord in hearing the matter on the 25th.
Well, then we'll say the 25th of October. Now, there was another point, Mr. Black, which I wanted to raise, which I have now recollect. The duration of this order is until trial or further order, or until further order of the court. And let's just turn that up. It's in paragraph 1.1. No, 2.1. Until the return date or further order of the court.
Yes, my lord.
Yes. I was just wondering whether it might be until the judgment has been fully satisfied or earlier order of the court.
My lord, we would be very content with that. We took a more conservative approach. We did think about that.
Well, in the authorities that you've cited, the orders that were made were until satisfaction of the judgment. Now, that may be in circumstances where there was an inter partes hearing, which was in effect on a return date. But it seems to me that the order ought to mark on its face the fact that this is an order that is parasitic on a judgment rather than a claim. And so I think the order should be until full satisfaction of the judgment. The order runs subject to any further order in the meantime.
My lord, yes, we'll put that in, and we're grateful for that, my lord. Thank you.
Now, are we done now?
I think we are. Thank you very much. Obviously, costs are going to be reserved.
Costs will be reserved. Yeah.
And we're very grateful for your lordship seeing us at such short notice.
The judgment is on the, I assume, on the DIFC website. In that sense, it's been published. Is that correct?
I have not. Yes, it is. Yes.
Right. Very well. Well, thank you for your submissions. I think that concludes proceedings for now.
Thank you very much, my lord.
Right. I'm closing down now.
Okay, thank you. Good day, my lord.
Good day.